Welcome to the Care Chronicles with a Caring Touch, where compassion meets wisdom in every episode, dedicated to our beloved seniors and caregivers. Join us as we explore the heartwarming stories, experts' insights, and practical advice that make every moment with our elderly truly special. Get ready for insightful conversations, practical tips, and heartfelt moments that warm the heart and nourish the soul. Because here at A Caring Touch, we believe in laughter, learning, and love as essential ingredients to aging gracefully. So tune in, relax, let A Caring Touch be your guide to making every moment count. Hi everybody, this is Avishka coming to you from A Care Chronicles with A Caring Touch. Today, I wanted to discuss legal and ethical considerations in elderly care. So discussing legal issues such as power of attorney, advanced directives, and guardianship, as well as ethical dilemmas in decision-making for elderly individuals, is what I'd like to discuss this episode. The resources for this discussion was received from healthcare guidelines that are already in place. And as a disclaimer, I am not an attorney in this matter, and it is best to contact your attorney for more information if needed. Decision-making for elderly individuals often involves ethical dilemmas due to the complex interplay of autonomy, well-being, and interests of family members or caregivers. So here are some dilemmas. Decision-making for elderly individuals often involves ethical dilemmas due to the complex interplay of autonomy, well-being, and the interests of family members or caregivers that are in play. So let's discuss 10 ethical dilemmas that are common in home health and hospice care, and just generally in elderly care. So respect for autonomy versus protection. The dilemma is between balancing the elderly person's right to make their own decision with the need to protect them from harm, where their choices might jeopardize their safety. So, for example, if an individual is refusing medical care or treatment or choosing unsafe living conditions, that would be a dilemma. An example is an elderly individual with dementia insists on living alone despite being unable to care for themselves safely. So this is a situation where the family member or medical social worker with the patient and the medical power of attorney will make mutual decision as to how to care for the patient and make sure that they get the best care they need. In second, I wanted to talk about quality of life versus prolonging of life. So the dilemma that's there is deciding whether to pursue aggressive medical treatments that may extend life by significantly reduce quality of life. So this would be an example like opting for life support measures for a terminally ill patient versus focusing on comfort care through hospice. Again, with situations like this, there's no black or white answer. It's typically gray. The decision is made with the medical power of attorney, their caregiver. Typically, it could be the same. And the patient, a medical social worker, and all of them would make this decision collectively. So the third one would be family wishes versus elderly individuals' preferences. So a dilemma is navigating disagreements between the elderly person's expressed desires and the wishes of family members who may have differing views about what's best for the individual. An example would be family members insisting on full medical intervention while the elderly individual prefers not to be resuscitated. So in this case, they would sign a DNR. Again, with situations like this, the decision is already made by the individual, so there is a dilemma at hand. However, the decision of the individual needs to be respected and adhered to. The next would be capacity and competence in decision making. So a dilemma would be determining whether this elderly individual is mentally competent to make decisions, especially in cases of cognitive decline, without unjustly overriding their autonomy. So you have to be respectful of this individual while also helping them make this decision or making the decision for them. An example would be deciding if an elderly person with mild dementia can still manage their finances independently. So the fifth dilemma would be allocation of limited resources. So a dilemma would be deciding how to allocate these limited resources, such as time, money or healthcare services in a way that is fair to the elderly person and others in need. An example would be choosing in between expensive in-home care or a more affordable group care option that may not necessarily meet all of that individual's preferences. However, these need to be weighed as to what the best option is for the individual again. The sixth dilemma that I wanted to mention was balancing privacy and safety. So balancing privacy of the individual and their safety. Dilemma could be respecting the elderly person's privacy while ensuring their safety, particularly in situations where surveillance or monitoring might be necessary. So an example would be installing cameras in the home for an elderly person to monitor their health versus respecting their right to privacy. So having that boundary set in place if needed, having that clearly outlined is something that would be very beneficial, useful, and probably avoid any conflicts that might happen down the line. So end-of-life decisions would be the next dilemma that I wanted to mention. So addressing ethical concerns around euthanasia, physician-assisted dying, or withdrawing life-sustaining treatment when these options are legally or morally contested. An example would be deciding whether to honor an advance directive requesting no artificial nutrition or hydration. At the end of the day, we need to respect the rights of the individual. So next, I want to talk about what an advance directive is. An advance directive is a legal document that outlines an individual's preferences for medical care and treatment in case they become unable to communicate or make decisions for themselves. It's important in elder care to ensure that the person's wishes regarding end-of-life care, resuscitation, and other medical interventions are respected. So an advance directive typically includes a living will and a medical power of attorney or a healthcare proxy. A living will specifies the types of medical treatments the individual wants or does not want. So this could include things like life support, artificial nutrition and hydration, or resuscitation. So in case someone does not want to be resuscitated, they would sign what's called a DNR, a do not resuscitate order, and that would be something in place with the living will. For medical power of attorney or healthcare proxy, we just talked about it. This would be a designated trusted person to that elderly individual that would make healthcare decisions on their behalf if they are incapacitated. So an advance directive helps guide healthcare providers and family members make decisions aligned with the person's values and preferences. It reduces confusion and also reduces conflicts during critical moments. These documents should be completed while the elderly individual is mentally capable and shared with family members. It should also be shared with healthcare providers and caregivers, and if needed, with financial institutions for the elderly individual to ensure that these guidelines are followed. So how can an elderly person get an advance directive in place? So similar to a medical power of attorney, an elderly person will first learn about the advance directives in place, understand the components, which include, again, a living will and a healthcare proxy of sort. So living will, again, for treatment preferences, and a healthcare proxy to appoint that would be a decision maker for the patient in case they are or if they become incapacitated. Next, reflect on wishes. So consider personal values and preferences for medical treatment. So this includes, again, life support, resuscitation, pain management, organ donation, and other end-of-life options. Consult with the professionals. Again, seek advice from a healthcare provider or an elder law attorney to clarify medical and legal options and ensure that the directive complies. So next, you would consult with a professional. So seek advice from a healthcare individual or an elder law attorney to clarify the medical and legal options and ensure that these directives comply with the current state law that you're in. Next, you would obtain the appropriate forms. So obtain state-specific advance directive forms. These are often available through hospitals, through healthcare providers, legal offices, or, again, online resources are an option. You would fill out these forms, clearly document preferences, and appoint a trusted individual to make decisions if you are unable to do so. Next, you would sign and witness the document. So sign the directive according to the state requirements. Again, this may include a notarization and or a witness signature. Next, you would again distribute these copies and review and update as needed. So make sure that these advanced directives, these documents are periodically reviewed and updated if circumstances held or preferences do change. So an advanced directive ensures that the elderly person's healthcare wishes are honored, providing peace of mind to them and their loved one. So next, I'd like to discuss what's called a guardianship. This is typically considered a last resort. A guardianship is a legal arrangement in which a court appoints a person or an entity, known as a guardian, to make decisions on behalf of an elderly individual, known as the ward. And this elderly individual is no longer capable of managing their personal, medical, or financial affairs due to incapacity, such as dementia or other health issues. So a guardianship is again considered often as a last resort where an elderly person does not have any other legal documents like a power of attorney or an advance directive in place, and this elderly individual is unable to make decisions to protect themselves from harm. A guardianship typically includes, for a personal guardianship, this selected individual would make decisions about the elderly person's healthcare, their living arrangements, and their daily needs. In terms of financial guardianship, this selected individual would manage the elderly person's finances, pay their bills, and protect their assets. To establish guardianship, someone, usually a family member, must petition the court, which then will assess the elderly person's capacity through medical evaluations and a legal hearing. If granted, the guardian must act in the ward, the elderly person's best interest, often under court supervision, and may need to report regularly on their actions and their decisions. A guardianship provides essential support for elderly individuals who cannot make safe and informed decisions, but it can also limit their independence, making it a serious legal step that should only be pursued when absolutely necessary. An elderly person cannot directly establish a guardianship for themselves, as guardianship is typically initiated by someone else when the individual is no longer able to manage their own affairs. However, elderly individuals or individuals generally can take proactive steps to avoid the need for guardianship by putting legal measures in place while they're still competent. It is advisable to speak to a specialized attorney in this subject. With that said, I'd like to thank you for tuning in to A Care Chronicles. Until next time, I'm your host, Avishka. Have a great afternoon. Thank you for joining us on this heartwarming journey with a caring touch. Be sure to check out our website and connect with us on social media for more stories, resources, and ways to get involved. We're excited for you to join us again in our next episode, where we'll continue to explore the beauty of aging with grace and compassion and dive deeper into topics that matter to our elderly community. Until then, stay connected, stay caring, and we'll talk to you again soon on the Care Chronicles with a Caring Touch.